agenda. Now listen, now we will take up a reply on the discussion of the Ministry of Law and Justice raised by Dr. E.M. Sudarsananda Cheppan. It was agreed to by the leaders. That reply will be taken immediately after the calling attention. Accordingly, I am calling the Minister, please.
Deputy Chairman, sir. Issues raised during discussion on working of Ministry of Law and Justice has given me some good feedback, and certainly I hope that it will strengthen me in functioning my ministerial works. As many as 19 members have participated, led by Mr. Nachappan. In detail, in length, the matters were discussed. I thank all the members for your valuable suggestions, and certainly I will assure to the members who have participated in the deliberations, your views will be taken, and certainly whenever things comes on that direction, certainly we will consider and we will take up the issues together with the suggestions that is given by all the members who have participated in the deliberations. But before going into the matter in detail, to reply the queries and suggestions by the honorable members, I would like to place on record the working of the Ministry of Law and Justice after this new government has taken over charge. Of course, the Ministry of Law and Justice, there are three departments, namely the Department of Legal Affairs, Legislative Department, and Department of Justice. The Department of Legal Affairs mainly handles providing legal opinion and legal advice to various departments, appointing law officers, conduct of government litigation and matters related to Law Commission of India. The Legislative Department deals with the drafting and vetting of various laws, enactments and rules being framed by various departments. Apart from functioning for election-related matters, the Department of Justice looks after the matters related to judiciary, ranging from appointment of and service conditions of judges, infrastructure for the Supreme Court and High Courts, judicial reforms and other legal aid to the poor. However, I would like to inform this August House that the issues relating to investigation and prosecution of cases and issues related to under trials and issues related to jail management are often linked with the law department. But this department has no role to play as far as those issues are concerned, except whenever the bail matters comes before the court, only the Department of Law and Justice will look into the matter. Rest all the matters are concerned to various departments, because Home Department is the main department which looks after all other things. Department of Legal Affairs, a national litigation policy has been already formulated. Mr. Nachappan knows very well. Law Commission of India has given a report, 251 report, wherein which has stated that a national litigation policy is very important because there are so many frivolous litigations, and to reduce the pendency of cases in various courts, a litigation policy, national litigation policy is required. Already various states have come out with the state litigation policies. So government has already working on a national litigation policy. We have drafted it. We are bringing it before the cabinet, and we are getting an approval so that it will reduce the considerable litigations which are pending before the court. The Law Commission of India was specially requested to give reports on various reforms of the government, keeping in view of the ease of doing business and good governance. it has submitted 7 reports for some important issues. Report of amendments on the Arbitration Act. Yesterday, so many of our friends, they have raised issues that ease of doing business in India is the need of the hour. So the Arbitration Act has to be amended, and some stringent laws should be incorporated in the amendments, so that arbitration should be made easier in India, and time-bound arbitration disposal should be made. So we have already arbitration amendments. I have taken it to the cabinet. I am bringing the arbitration amendment bill before the Parliament at the earliest. Report of setting on commercial courts and commercial division in the higher courts, that already I have moved that bill before this court, this House. So it is for consideration. Report on amendments to be brought on Prevention of Corruption Act. A cabinet approval is already taken on this also. So we are moving that bill. Repeal of obsolete and obsolete laws. That is one of the important areas there. There I moved 2 bills, and one appropriation, repealing of appropriation bills of 758 appropriation bills acts are also placed before the Parliament. Department has proposed to decentralize the legal assistance to various ministries and departments, providing Indian legal service officers to be stationed in each department level, so that legal opinion for all proposals can be speeded up. This is one of the important area, because all departments should have their own legal officers, so that the department can dispose of the cases at the early. Of course, we have recently, our department has opened a new branch office at Bangalore to cater the needs of the requirements of the southern states. Legislative department is one of the important departments where my friend also referring that some laws it should be made some simple, so that each and every individual can understand the law. So department, this department has drafted a huge number of bills. The 24 important bills of various departments has been drafted since last 6 months, and department also drafted about 11 ordinances, of course, various departments and ministries in a short period of 6 months. The department has drafted about 13 amendment acts in 6 months. Department has also scrutinized 23 state bills and ordinances. Department has repealed about 35 original acts by passing the bill in the Parliament. The department has examined repeal of 197 amending acts, and already moved a bill to repeal about 758 appropriation acts. Department of Justice is one of the area where almost all the speakers spoke with regard to the speedy delivery of justice and speedy disposal of the cases. Major achievement of this department is bringing the Judicial Appointment Commission Bill by enacting the Constitution and the National Appointment Commission Act 2014. Of course, I don't want to talk much about this, because the matter is pending before the Supreme Court. Already the government has taken steps. We have already notified the Act, and in fact, the matter pending before the Supreme Court, it amounts to sub judice, so I don't want to traverse in detail as far as this matter is concerned. No, I will come to that. No, supremacy, sir, the supremacy of the Parliament, certainly I do concede that the supremacy of the Parliament should be there. At the same time, independence of the judiciary also should not be encroached upon. So to a certain extent, the government should see that the independence of the judiciary. Of course, I would like to place before this court, before this House, that almost all the proceedings to bring into effect the Act was taken seriously by the government. It was taken seriously, we have notified it, Afterwards, we wanted to have appointment of two eminent personalities, selection of two eminent personalities. But the Chief Justice of India, he sent a letter to the Prime Minister stating that as the matter is pending before the court, I am unable to participate in the proceedings, so the matter was struck. So we sought the directions of the court, what should be done when the matter is pending before the court, how we should go, we should select two eminent personalities. The directions of the court will be certainly followed by the court, by the government. Of course, I too feel that you are rightly said, Shantaram Naik, Honorable Shantaram Naik has rightly said that the supremacy of the Parliament that has to be kept up, and it should not be taken away by anybody. So, if NJSC comes into fully functional, the filling up of the post can be speeded up, and there will be a sharp decline in the pending cases also. I don't dispute that fact. Of course, there are few areas that we have sum of rupees 933 crores have been released to the states during the year 2014-15 for infrastructure development of the subordinate judiciary. About 2,251 court halls and about 1,799 residential units for judicial officer of district and subordinate courts are under construction. The sanction strength of the High Court judges has increased from 906 to 998. The sanction strength of the judicial officers in district and subordinate courts have been increased from 19,518 to 20,214. Against the target of computerizing 14,249 district and subordinate courts in the country under e-court mission mode project, 13,672 courts have been computerized at the end of the phase 1 of the project on 31st March 2015. We are taking up the phase 2 e-court phase 2 project also. We are already taken the cabinet approval for the same. Department has set up a national judicial data grid to provide online access to case data in respect of more than 4.5 crore cases and about 95 lakh judgments. This data can be assessed by lawyers and litigants and also by common men if need be. Pendency of cases in the district and subordinate courts has declined from 2.68 crores from 31/12/2013 to 2.64 crores as on 31/12/2014. Pendency of the cases in the high courts has also declined from 44 lakhs as on 31/12/2013 to 41 lakhs in 31/12/2014. Of course, these are the three departments of Ministry of Law and Justice, and we are working on it to see that all possible efforts are being done to fill up the vacancies, to come down with the pendency of the cases, and all the infrastructure and other benefits should be given to the judiciary. Of course, there is Dr. Nachappan has raised a very important issue with regard to the development of international law and bilateral agreements that should be handled by a Ministry of Law and Justice. He said that now things are moving in a faster direction, so the international law and bilateral agreements should be handled by Ministry of Law with a separate wing in the Department of Ministry of Law and Justice. Of course, there is a move by the Ministry of Law and Justice to see that a group of secretaries, they should sit together to draft this bilateral agreements, and that should be vetted by the Ministry of Law. Now, at present, it is with the External Affairs Ministry, and as per the As per the allocation of business rules 1961, each department will have their own wing wherein they will draft all these things, and later on finally the law department will look into the matter whenever it is taken to the cabinet. So therefore the implementation of treaty relating to any matters allocated to this specific ministry is a subject concern of that ministry. So only in certain cases when the subject matters have been assigned to different ministries under the allocation of business rules, the role of the administrative ministry arises as and when the treaty is related to one of the subject assigned to it. Of course, the Ministry of External Affairs being the nodal ministry dealing with the international law assists in facilitating the negotiation and conclusion of such treaties. And whenever the ministry's law is required to be consulted as per the transaction business of rules, all litigative proposals, before the proposal is brought before the cabinet, we are assisting them. Certainly your suggestion is certainly well taken, and we will see to it a separate wing in the Ministry of Land Justice should be there. So we will work on it in the coming days, and we will take serious note of your suggestion. Another important area that has been debated yesterday was pendency of cases in the various courts. I would like to say that it is not in the domain of the government. The disposal of the cases is in the domain of the judiciary. As I said earlier, we don't want to encroach upon the independence of the judiciary. But still, there are several aspects which need to be taken care of by the government to assist the courts to have a speedy disposal. Even then, the pendency in the courts are coming down. Since last 4 years, I can give you the data, because the institution or because of the new cases are coming in huge number, and the pendency has also gone high. But at the same time, of course, I don't dispute that there are several areas that need to be taken care of, then only the pendency can be reduced. Since last 4 or 5 years, that's right from 2010, I have got the statistics. The Supreme Court, 61,081 cases are pending as on 1st March 2015. But in the year 2012, it was 66,692. In 2013, it was 62,791. Now, this is reduced. Against that, the institution number has gone up. In 2012, 76,917 new cases have filed in the court. In 2013, 76,742. In 2014, 89,164 cases have been filed in the court. So the filing of new cases has gone up, but subsequently the pendency has come down in Supreme Court also. Of course, in Supreme Court, 3 vacancies are there. The disposal of the cases in the High Courts also has since last 5 years. I can give the statistics. In 2010, institution of new cases, that is about 18,64,975. Pendency was 49,344. But in 2014, it has come down substantially. It has come down. Now the pendency is 41,53,957 as on 31/12/2014. So even in the subordinate courts also, sufficient cases have been disposed of, even though the filing of the cases has gone up. 2010, 1 crore 80,000, 4,311 cases have been filed, new cases have been filed. Yeah, in 2014, it is 1 crore 89 lakh 57,997. Now the pendency has come down. Pendency in 2004 was 2 crore 77 lakh 51,181. Now it has 2 lakh 64 lakh 88,405. Of course, I do consider that the disposal is not up to the expectation of the litigants or the public, but still there is a substantial decrease in spite of the vacancies are not filled up in the court. I would like to place before this House the various reasons for pendency. Reasons for pendency, increasing number of state and central legislation is one of the important reasons. Accumulation of the first appeals, continuation of ordinary civil jurisdiction in some high courts, and vacancies of the judges, appeals against the orders of quasi-judicial forms going to high courts, number of revisions, appeals, adjournments, indiscriminate use of writ jurisdiction, lack of adequate arrangement to monitor, track, and bunch cases for hearing. These are the main reasons for pendency. Of course, several measures have been taken by the government to reduce the pendency in courts. Pendency reduction drive has been launched during the last 4 years. Mega Loka Adalats have been conducted. Chief Justice of High Courts have been repeatedly requested to take advance action for filling up of backlog vacancies as well as anticipated vacancies in the High Court. In principle, concurrence has been given to increase the sanction strength of High Court by 25% to the existing strength. State government has been requested them to operationalize the all sanction posts by filling up vacant posts of judicial officers. Under the e-court project, 13,672 courts have been computerized by March 31st. State government have been encouraged to notify state litigation policies so as to reduce the government litigations. These are the various steps that has been taken by the Ministry of Law and Justice to see that the speedy disposal of the cases. Of course, even other areas also covered by us. As far as infrastructure is concerned, there were, as of 30th June 2014, there were 15,419 court halls, courtrooms available for the functioning of district and subordinate courts. In addition to that, 1,003 courtrooms were available in rented premises. Comparing to the figures against the working strength of 15,634 judges as on 31st December 2014 reported by the High Court, it is noted that adequate infrastructure is available to the current judicial manpower. Because yesterday one of my learned members said that somewhere the court is run in toilets, but it has not brought to our knowledge so far, but it is not true also. So sufficient courtrooms are available. Further, there are about 2,251 additional courtrooms are under construction, and which these are in various stages. Of course, there are 3 posts vacant in Supreme Court as on 24th April 2015, and 366 posts of judges are vacant in the High Court. 4,580 posts of judicial officers are vacant in district and subordinate courts. I think if the NJSC comes in fully functional, I think all these issues can be resolved, and certainly we can put an end to this. National litigation policy is one of the important areas. As I said, the national litigation policy is under consideration of the government. An informal team of ministers consisting of Home Minister, Finance Minister, Minister of Road Transport, Law Minister, and Minister of Communication and IT, they may meet and evaluate the proposal, and we will bring it as early as possible. Another one area that is important area is that National Legal Service Authority. National Legal Service Authority, Lok Adalats are being organized for amicable settlement of disputes. This has reduced the pendency of cases in a large extent, thereby reducing the litigation expenses also. In the second National Lok Adalat, it was held on 6th and 13th December 2014. Nearly about 40 lakh cases pending in courts. This is 40 lakh 81,637 cases which are pending in courts were disposed of, apart from the pre-litigation stage cases. So this Lok Adalat has played a very important role as far as disposal of the cases. Some of my friends, they have raised an issue that why a national judicial service should not be formulated. If that is National Judicial Service Commission is formed, then automatically it will be, so many things will be resolved through that. The views of the views advanced by my friends that National Judicial Service Commission should be brought at the earliest. Of course, proposals were taken in this matter, and the proposals were sent to the states and the High Court judges. Majority of the High Court and states have strong reservations against this matter. High Courts, they are having in mind that High Courts will, they will lose control over the subordinate courts, and it will dilute the administration of the subordinate courts, and they say that some language problems also will arise, and promotional chances also will be reduced. Of course, some of our friends, they raised issues that bench, Supreme Court bench should be established in the southern part of the country. That is, I am coming. Yes, yes. Of course, my friends are from various corners. They wanted to have a High Court benches in various
Most of the point you have
just
dealt
like
with.
in Kerala, my friend has raised, and in Uttar Pradesh, they are also raised that issue. One minute. Yes, yes.
I also want.
Only thing is, the High Court benches could be established. If a proposal comes from, yes, Goa also rise. Yes, the High Court benches can be established if there is a proposal from the state government after due consultation with the Chief Justice. Certainly the proposals will be considered. We are. No. But as far as this is concerned, of course, I don't say that the Parliament doesn't have power and all those things. I will not say, because even the Parliament can, as it is said in the Constitution,
All right, there your assurance is enough that you will try for that.
yes, certainly not. If a proposal comes from any states after due consultation with the Chief Justice of that, the government we will consider that and we will
No, but there are
take the positive
instances-
steps in that direction.
Mr. Minister,
Sir,
there are instances where the Chief Justice
tell me, sir.
does not agree. Then what you will do? No, let him finish. Have you finished?
No.
I think you dealt with all points.
No, sir. Only two more things. Yeah, as far as the benefits for advocates are concerned, and as far as the assistance to the junior lawyers, that was also raised. They raised an issue.
Yes.
As per the Advocates Act, we can see there are several benefits are being given for the advocates who are enrolled on under Advocates Act. Their benefits, whom anybody, if they want any assistance, certainly through Advocate Act it is being given. Sir, as far as the benches are concerned, one more thing I would like to say that there are, so as far as Supreme Court benches are concerned, of course, proposals were moved, but after judicial scrutiny only it can be finalized. It was sent to the Supreme Court twice, but Supreme Court has declined. The full team, they sat together and declined to have any benches in any parts of the country. So all these areas that we have traversed, so in future, if any proposal comes, the government certainly will try its level best to see that speedy justice of justice delivery is one of the important areas that we will take care of.
Thank you very much. Thank you very much. Okay, Dubey sir. Duaji.
I would just need a clarification from the Honorable Law Minister. He has not touched on the aspect which has become very, very important. The three organs of the state, Parliament, Judiciary and the Executive, are supposed to function in an atmosphere of trust, with restraint and caution. What we are witnessing today in the atmosphere is clear confrontation is developing between executive and the judiciary. I will not go into the cases, why it is developing, how it is developing, who is to blame, but it is palpable confrontation is developing which needs to be checked at the right moment. Will the minister assure this House and the country that the government will do everything possible lest the confrontation becomes more serious? Thank you.
Thank you, Raja.
I am raising this question which is exclusively in the domain of government, sir, not in the domain of judiciary. Several members raised the issue of providing adequate representation to SC, ST in the appointment of judges. Whether government will give thought to it, considering such a proposal, this is one, sir. Secondly, number of cases of massacres of Dalits have ended in acquittals in High Court and trial courts level. Since Minister for Social Justice is also there, whether government is thinking to go on appeal on all these cases, because it is very sensitive and very important in relation to our justice, delivering justice to SC, ST people.
Okay, Sriya K. Anthony.
Successive governments in Kerala are consistently demanding a High Court bench in Trivandrum for the last 25 years. I also took it up as Chief Minister twice. So all governments, 25 years we are consistently demanding. And we are consulting the Chief Justice. But unfortunately, Chief Justices successively they are not agreeing to it. So what is the meaning of consultations? Because when 25 years, there's unanimous request from the state governments and all political parties and the bar associations of Trivandrum. Every agitations are going on, it is continuously. Please find a solution to this.
No, Kashyap, yes.
पिछले 40 सालों से पश्चिमी उत्तर प्रदेश में हाई कोर्ट बेंच की स्थापना का संघर्ष पश्चिमी यूपी के किसान, वकील सब लोग करते आ रहे हैं। मैं जानना चाहता हूं माननीय मंत्री जी से कि क्या पश्चिमी यूपी के 10 करोड़ से ज्यादा आबादी में रहने वाले लोगों की सस्ते न्याय की कल्पना को पूरा करते हुए पश्चिमी यूपी में हाई कोर्ट बेंच की स्थापना करने का आज ऐलान माननीय मंत्री जी करेंगे? और दूसरा, SC, ST, OBC रिजर्वेशन सुप्रीम कोर्ट तक मिले, इस पर भी अपना जवाब देने की कृपा करें। धन्यवाद।
Sir, first is about the High Court bench. Respected member Sri Akanani said the same question. I also raised this issue. And a recent reply, Minister said that the High Court is not accepting the demand for a bench. So that you continuously for 25 years, if they are saying that we are not accepting, we are not accepting, we are not accepting, we have to change that scenario. That is the first thing, what the government can do. And sir, second is, Minister said, there is in the Advocates Act, there is some provisions to promote and support the junior lawyers, because junior lawyers needed to be promoted with some financial support. I raised, while speaking, I said that like JRF in UGC, under UGC, there should be a separate scheme for 1,000 or 2,000 fellowships for 2 year or 3 year. They can be used for legal service authority, any other authority. By that way, through a national test, junior advocates can be selected for the scheme. What is the reply for that?
Ramesh.
I have one suggestion to the Honorable Minister and one question. So the suggestion is that repeatedly, when this issue of pendency comes up, macro statistics are given, so many cases pending in Supreme Court, so many cases pending in High Court, so many cases pending in the district courts. So that by itself does not convey anything, because as the Honorable Minister himself has admitted, the number of laws have expanded. So it is better for governments to present the time distribution of pendency. It's very difficult to get this information out of governments. I have tried, it's been very difficult even for me, being in government. We only get so many 60,000 cases pending, 2 crore cases pending. I was like, it is much better and is much more useful to have what is the time distribution of pendency. How many is pending more than 1 year, pending more than 2 years, how many are pending more than 5 years, so that you really know what the crux of the
Sugandhar Roy the other day said,
there's a second
the case
question
50
I have.
years pending.
So the question I have, yesterday Mr. Shugendu Shekhar Roy raised one issue, and I would like the Honorable Minister's response to that, because he raised the issue of the Bail Act, that you need to codify the conditions under which we get bail. Now we know that there are huge variations within this country under conditions under which bail is given. I would like the Honorable Minister to reveal what his thinking is on the suggestion for having a Bail Act in India.
Rangarajan, put the question, that's all.
Sir, I support the points raised by Honorable
No,
Member
you need
Jairam.
not, you only ask clarification.
No.
You
See,
need not support
the
him.
The cases are pending. The poorest of the poor are standing before Supreme Court, High Court and District Court.
कहाँ है?
So when will they get the relief? Otherwise, you know, the police intervenes and rowdies intervenes, they try to settle, there also innocent is affected. Second, there are states
Question.
which has not passed the Lok Ayukat Act. What is the government position on those governments, whether they will insist on to pass Lok Ayukat Act as early as possible?
If, Minister, if you have the reply now, you give. If you don't have, you can write to them later.
Only two things. Sir, as far as
One small
Okay, one question, 1 minute, okay.
Sir, the Honorable Minister mentioned that the government has hardly a role in controlling the pendency. That I agree. But I suggested yesterday one thing. 40% of the pendency is cases where the government itself is involved. Now, government going against its employees. Many times it happens, employees, the things which can be sorted out in the government, they say, no, you go to the court. Now, at least can the government take a decision that people go to the court. But for appeals, the government should not indulge in appeals against the court decisions against the employees.
Okay, Mr. Minister, please.
Mr. Chairman, sir,
And spending
one
money
important,
also.
issue that has been raised by Honorable Member Tulsi, that there is a confrontation between...
No, Duvaji. Duvaji.
I don't think that there is any confrontation in the three wings of the government. There may be difference of opinion. If there would have been a confrontation,
You will sort it out.
You might have seen recently the matter is pending before the court. In spite of that, government says that we don't want to encroach upon the judiciary. At the same time, we want to say that our parliamentary democracy also should be given high responsibility. That is what we are telling. So there is no confrontation as far as that matter is concerned. As far as the High Court benches are concerned, the infrastructure need to be provided by the state government. And the management of the court affairs and other things will be done by the High Court. So there should be a proper proposal from the state government after due consultation with the Chief Justice. Then only government go ahead with this, sir. One more issue, that is with regard to the advocates, especially junior advocates. That is what raised by my friend. Under Advocates Act, Welfare Fund Act 2001, which entitles social security for other persons. Of course, as far as the junior advocates are concerned, usually it is the concern of the state government. Every state government, in some of the state governments, they are providing some stipends to the yes, advocates. But it is a issue that need to be taken care of. Certainly, that issue needs to be taken care of. And as regards the High Court benches of Western UP, in the recent communication from the Ministry of Law and Justice, the Chief Justice of Allahabad High Court has stated that there is no proposal from the state government in this regard. So we are unable to take up that issue as far as Uttar Pradesh is concerned. But Honorable Senior, our former Minister Antony's views, certainly if your government is there in Kerala, so if you are able to coordinate with the Chief Justice of Kerala High Court and with the Chief Minister, and if you send a proposal, certainly the government will look into the matter and we will take care of the things. Yes, sir, certainly. My friend says I will verify it if there is a proposal from Orissa by the Chief Minister, and if acceptance is given by the Chief Justice, certainly we will look into the matter. Yes, I will look into the matter. Yes.